Well, we're very fortunate to have a distinguished group of panelists this evening representing a cross-section of the industry. Our moderator, to my far left, I should say, will be Alex Montague, who has represented Lipper and Thomson Reuters for the past 11 years. Alex is the founding partner of Montague Law and is responsible for advising a diverse clientele on a wide variety of domestic and international commercial and corporate transactions and managing litigation. In addition, Mr. Montague has been an arbitrator on a number of cases before the International Chamber of Commerce. He's also a regular speaker at international conferences on a wide variety of intellectual property, business, and legal matters. Mr. Montague received his JD with honors from Harvard Law School and his undergraduate degree from Princeton University, graduating summa cum laude. He also has bachelor's and master's degrees in law from the University of Cambridge, where he received double first-class honors. From fund management, we have John Hamalian. Mr. Hamalian is Senior Managing Counsel and Managing Director, Asset Management at the Bank of New York Mellon Corporation. Mr. Hamalian is also Vice President and Assistant Secretary for the various investment companies which constitute the Dreyfus family of mutual funds. Mr. Hamalian received his undergraduate degree from Bucknell University and law degree from the University of Pittsburgh. Giving us the legal viewpoint today will be Marco Adelfio, a partner in Goodwin & Procter's Business Law Department and a member of its investment management practice, where he focuses on representing investment companies and investment advisors. Mr. Adelfio joined Goodwin Procter in 2009 and is based in Washington, D.C. Prior to joining Goodwin Procter, Mr. Adelfio was partner in the Washington, D.C. office of Morrison & Forrester. In addition to being a regular conference speaker and contributor to industry publications, Mr. Adelfio recently contributed 2 chapters to Investment Management Law and Practice, a treatise published by Oxford University Press, analyzing the legal and regulatory environment in which investment management firms operate in the United Kingdom and the United States. Mr. Adelfio earned a bachelor's degree at Bucknell University and a JD from Boston College Law School. And Richard Showalter will provide us with the independent trustee's perspective. Mr. Showalter is the lead independent director of the Sentinel Funds, a position he's held since 2005, and has been an independent director at Sentinel since 2003. Mr. Showalter has held the positions of Senior Vice President, Treasurer, and Chief Financial Officer for companies within the Dartmouth-Hitchcock healthcare system, where he served for 25 years. Mr. Showalter is a graduate of the University of Massachusetts and a licensed certified public accountant. Alex, if you'd be so kind.
Thank you very much, Darren. We want this to be more in the form of a discussion, so we're not going to hold questions to the end. We very much encourage you to ask us and sort of join the panel. It's a small enough audience that I think it would work. So feel free to raise your hand, and as long as we're sort of not in the middle of speaking, the microphone will come and you can basically join our panel. But let me start with you, Dick. I want to ask you to give us a little bit of background on your role as a director. You've been in this role for a number of years, and having listened to what Bruce just described and a number of new initiatives that the SEC has taken and the setting up of this asset management unit, tell us a little bit about how that role has changed in light of these issues, especially in the last 3 years.
Okay, Alex, thank you. I'd be happy to do that. In fact, I've prepared a few remarks. I appreciate being part of the panel today. It's an honor to be asked to do this. I thank Lipper for putting this on. I think these are important ways for directors and other people to sort of develop best practices and understand what the issues are. Thank you, Bruce, for your comments. It's always interesting to hear what's going on at the SEC. I have to say, as an independent director, I feel like with the SEC, their interest is in protecting investors, and independent directors have an interest in representing the interests of shareholders. So the missions aren't exactly the same, but they're certainly very compatible. And obviously, I think we can work together. a little bit of my background may be valuable to understand the comments I'm going to make. And let me start off by saying that the background of all independent directors is we desire diversity on the board, like most boards, if you will. Many of the board members don't have investment company experience. And I think that has a lot to do with the need to have good working relationships between the advisors and the directors and amongst themselves. My background is unique. I haven't run into anybody else who is a financial person from a healthcare background. But actually, I think my role as an institutional investor, my role in putting together 401k plans for our employees, composed of 30 different mutual funds on a platform, gives me sort of a user's perspective of mutual funds, and also my oversight of compliance programs, internal audit structures, and actually conflict of interest process in that field I've found to be beneficial. As a CPA and a CFO, obviously, that background in terms of reading financial statements was useful. Accordingly, I came on the board right after Sarbanes-Oxley. I think a lot of people were looking for financial experts. Some boards didn't have them. So when I came on board as an independent director, I was immediately designated as the financial expert on our SEC filings. Our board, I come from a small mutual fund, a family of mutual funds. It has about $9 billion of assets under management. So I'm not sure if that's small, medium, or large. I know it's not as big as Dreyfus there. And I think that every board is a little bit different. It has different operating issues, if you will. Ours is growing, thank goodness. It's growing because we've had good results and low fees. We've also spent some money on marketing, and there's been some acquisition. So those have eliminated some problems for us, but also created some interesting challenges in terms of what kind of due diligence to go through. Most of our shareholders come from the retail market, although that's changing. There's a lot more institutional investors, and the platforms, on the platforms we're selling institutional shares to those instead of retail shares. As the lead director, my job, as many of you probably know, and maybe I could stop here for a moment. How many in the room are actually independent directors in mutual funds? So there's about 10 of us in the room here. I'm sure you all folks know what a lead director does. For some of the others who may not know, my job is to coordinate the activities of the independent directors, and act as spokesperson for them. By law, we're required to take many actions which exclude management and the affiliated directors. And so when we do that in executive session, we'll come up to an opinion. So my job is to coordinate that, and also then to be the spokesperson with management on what we've decided to do, if you will. But also, my job involves working with management and working with the affiliated directors. So I work very closely with the chairman, who's an affiliated chairman, to construct an agenda that meets the regulatory requirements, but it's also an effective and efficient use of our time. Now, I was asked to comment on how our board has changed with respect to regulatory changes. But I'd like to set context for that initially. Certainly, I think all the board's members that I talk to at the sessions that I go to are seeing a lot of change, and our board has changed too. And I'll get into some of the details of that in a moment. But I think our board has changed from 4 different factors. 1 is regulatory changes, 2 is litigation, 3 is forums like this, industry forums where directors and managers talk about what is best practice, how to get the information you need, what is adequate information. But I would say there's a 4th way. And I'm proud to say that I think our board has changed because of the internal discussions we've had in our board about what's in the best interest of our shareholders. So all those things combined have helped us to change. So let's go back to the influence of regulatory and litigation changes on our particular board. I think everyone in the room probably knows, but I'll repeat it anyway. The Investment Act of 1940 is probably more than any other single factor, the biggest influence on what we do, what our mission is, and how we do it. And there's a lot of detail in that on what we should do. But let me cite two other examples and give you my personal reaction to them. By the way, I should have said my comments are my own and not my board or my fund, if you will. I should also claim that I'm a New England Patriots fan, and I know that I'm not in that countryside here. But what I'm hoping for is a rematch of 2007, and I must remind you that past performance is no indication, no assurance of future results.
Well, Tom Coughlin lives in
I'm
my
hoping.
condo complex.
I'm hoping.
And we've been walking our dog in front of his house every week, and they've been raining ever since. The
You
dog's
can,
got a
you can
Eli
see
Manning
that.
shirt on, so
the
I think
panel,
the Giants
the
are
panel's
going a long
moving
way.
along.
We're going to keep bringing that dog out.
I'm not sure I'm going to sit between the two of you.
Oh, I don't care that much.
Well, the first example I'd like to cite, which was of great benefit to us, was the SEC's 2011 concept release on the use of derivatives. This came out along with a companion document. There was a letter on the record issued by Barry Miller of the SEC in 2010 relating to disclosure of derivatives in prospectuses. These two documents were very useful in our board as we just launched a bond fund. And we were going to use derivatives for risk management, for hedging against currency and interest rate risk, things like that. Pretty vanilla stuff in terms of derivatives here, but our board needed a good education on that. And so the directives from the SEC were very helpful. They were helpful for two reasons, I think. One, obviously the SEC is a very authoritative body, so what they said was well thought out and very comprehensive. But two, it allowed us, the directors, sometimes with backgrounds that didn't include a lot of education on derivatives, to enter into a conversation with our advisors on, we read about this in the SEC document, what are we doing in that regard? Do we have this issue? So it actually posed many questions that we could use in our discussions with the advisors. So it resulted in a good discussion, I think. The second example I'd like to talk about that I don't think has had much of a change to our board, but it has made me think about things, and it's made me have a couple of conversations with our compliance officer and our legal counsel, who happens to be in the room here today. I'm not allowed to go out alone on these things without adult supervision. In the Janus case, recently heard by the Supreme Court, as I understand it, by a 5-4 margin, the court affirmed the responsibility of the board for statements in the prospectus, but relieved to some extent the responsibility of the advisor. So I have two reactions to that. One, my first reaction is that I still think the advisor has a lot of responsibility for making sure the disclosures are right. Number one, they have the expertise, they have the knowledge, and they're the actual drafters of the language. We just review it, if you will. And so whether the Supreme Court thinks that they don't need to be responsible for the statements that are made, I think our board still thinks that the advisor does have a responsibility, at least to us, by the advisory contract that they enter into with us. And I believe the advisor thinks they have a responsibility to do a professional job too. My second reaction is this, though, and it may be a stretch, and I'll remind you that I'm not a lawyer, but it seems to me that if you can say that only the board is responsibility and the advisor is not, or has some limited liability, which I don't believe here, then that's all the more reason for the board to get involved and understand what's going on, not just in disclosure, but in all the things that the board does. Because ultimately it is the board's responsibility on who is hired, including the advisor, and how things function. Now, this creates a dilemma for our board, and I think for every board, as evidenced by one question a little earlier. Our board generally feels that we should become more knowledgeable. But the question is, how much detail should we ask for? How much time should we take? Too much information, and we're accused of micromanaging or getting into management's business. Too little information, and we don't actually know what we're talking about. We don't know what we're looking at in our oversight responsibilities. My business background tells me that when staff, and I'm thinking of myself as a CFO presenting to a board, when I knew that the board was going to ask thoughtful, pertinent questions, I thought my staff did a better job. So I think if our shareholders are benefited by an active board with a good questioning practice, that's good. That's a good thing. So I would err on the side of asking the advisors to let the directors ask whatever questions they have, whether strategic, managerial, operational, whatever, because they need to get comfortable with it. And that's, I guess, my definition of what's adequate. When I feel comfortable, and that's hard to describe, then I'll go on to the next topic. But when I'm not, I'll ask one more question. Just quickly, the way our board has changed, we have more meetings, they're longer. The number of telephonic meetings, special purpose meetings have increased. The level of knowledge on current events, whether it's the Janus case or derivatives, has increased. So not only do directors need to come up to speed fast, understand what 12b1, 15c, all the lexicon from the SEC Acts and stuff, what those are, but there's a lot of current things going on too. While the basic process of our 15C processes remain unchanged, we are asking for more and getting more information. We've engaged outside experts, independent experts, to evaluate our process and reacted accordingly to those comments here. We've commissioned special studies on particular areas of interest. For us, understanding transfer agent and sub-transfer agent costs on the platforms was something that we're interested in. Those will continue. We've also developed understanding with staff on the protocol, the deliberative protocol we'll have on reviewing and approving complex issues. We want multiple bites of the apple. We don't want things presented to us and a decision asked for that same day. So I'll conclude by saying that I'm fortunate that at Sentinel we do have a management team, I feel, that recognizes the value of acting in shareholders' interests and having an informed and active board. I hope you find these comments helpful, and I haven't gone on too long.
No, thank you. I know, John, that you have some thoughts about some of the things that Dick just mentioned, but let me make that a little more specific and ask you to tell us about your relationship as an advisor with your boards, and whether it's similar, whether also you've noticed any change as a result of some of the SEC initiatives that we heard about today.
Okay. I guess I'll spend 1 minute just to say that we are, our fund board structures are probably a little bit different than most. Even if you go all the way to the Fidelity's 200 funds, it's one board. We used to have up to 11. We've consolidated them down to about 7. And so we have sort of groups of funds that are served by a single board, and each board has a joint board meeting, but only with respect to that number of funds. Some directors will sit on multiple groups. We have one single chairman that sits on all of the groups. He's the only one that's on every board. He's the one that management really speaks to. He carries the lead director role, but we've appointed him, the board appointed him, not me. The board appointed him as chairman as opposed to lead director. It's an alternate structure. So we have a lot more meetings every year, and we have about 32 directors, I think, total in the complex that we, speak to through the staff. So in any of my comments that have to do with board, I might just be really referring to our dealings with the chairman, but we have multiple boards and multiple 15C reviews. In a way, we're doing them all year long. Our boards meet staggered over the quarter to quarter. Sometimes directors are seeing things multiple, maybe 8 times a year, maybe 12 times a year. So it's almost like an audit process. It's going on all year long. It's not just a snapshot one-time thing. Our chairman is certainly seeing this, every month all year long. So that's a little bit different. I have one comment to your Janice comment about the prospectus, not to argue, just to supplement. I don't have any issue with that case. If anyone's not familiar, it was simply, and I think you'll certainly give us more about it, it was who owns the statements in a prospectus, essentially. And the court somehow people were surprised at this, said the fund owns the statements in the fund's prospectus. I don't see any illogic to that conclusion, notwithstanding the fact that the advisor is paid as an administrator to help write it. But you're paid for everything as the advisor. But to suggest that the prospectus doesn't belong to the fund and the statements in it don't belong to the fund, I think might be a little crazy. Where I think the advisor's on the hook is in implementing what's in the prospectus. And that's everything. That's the goal and approach. That's the services that you provide. That's your revenue sharing. That's everything. In the Janus case, it went down to market timing. And if the fund made a statement that said, we will prevent this from happening, and then the service provider didn't prevent it from happening, well, that's where regulatory action comes in to that behavior and activity. So and that's where it gets caught. So I think the advisor, certainly its obligation is to implement everything that's in the prospectus, and the board's role is to see, is the advisor implementing what's in the prospectus properly? And that's goal and approach. That's, was the portfolio performing the way you expect it to perform? Are shareholders being serviced properly? Are there complaints, things like that? Is distribution payments being made properly? Asset flows, all of that. That's why the advisor reports every quarter. It's fulfilling its obligations as set forth in the prospectus. As far as whether our board meeting process and that has changed, I don't think the litigation has really changed it. The regulation has certainly changed it. It's much more voluminous, much more complex. I think the CCO rule definitely impacted how boards do things. Over time, it's, I think, been a great benefit to boards to be able to rely on the CCO's certifications to things that you don't need to review in so much detail at meetings anymore. So I think that has certainly changed how we deliver materials, how we report. If you trust your CCO, I think for boards it's a great thing. But I think the biggest thing that's changed the way what we do is how the market is performing. Our boards are very in tune to performance. We have all kinds of funds. We're a cash manager predominantly, but we have fixed income, international equity. Performance is always on the minds. But now, if the 15C process has almost gone a little bit the other way. The markets are so crazy that you are reviewing money market funds, for example, at a 0 yield versus a 1 basis point yield. How does a board review that? How does a board consider the fact that the advisor, maybe has absorbed, tens of millions of dollars in fees every year to keep at least the yield on a money market fund at 0 or slightly positive? For bond funds in a market like this, when analysts are calling for municipal bond funds to be defaulting across the board. If your advisor or your portfolio people are convinced that I must manage the downside risks, that there's no surprise for the long-term return to be better, and you're underperforming maybe in a year or two on your 15C, now how does the board look at that? In a bull market for bonds, everyone's going up, but in a bad market, you're managing differently. And so now a board is maybe looking at, well, is first quartile maybe that bad? Do I support the decisions of the portfolio managers and their process? So I think the whole thing has kind of gone a little bit on its head, where you used to look at maybe the advisor's profitability, looking at the health of the advisor. Now, you have to have a healthy advisor or the funds don't have, a provider. They don't have a home. So I think the market has changed more than the litigation has, and certainly the regulation has, heaped it on. Some of the new litigation is interesting, but I think I'll wait till you maybe speak to that a little, and we'll talk more about it.
Yeah, well, thank you. I'm going to just get to this Janus case because we don't seem to be able to get away with it from it. But on this subject of the fees, evaluation of fees, this is something that Bruce brought up as well. And in this environment, this seems to be something that the SEC is focusing on. And from what he was saying that they are looking to the boards to be able to be particularly vigilant. Now, Dick, maybe you could comment on that. Maybe someone in the audience. We have quite a few trustees. What is the experience of boards? I mean, I know you have a particular actuarial background and you can do this. Do most board members have the necessary background to be able to get into these detailed financial analyses to understand and evaluate this? And if not, who do you have to help you do that?
You're talking about fees,
Yeah.
fee issue in the Janus case?
Yes. I'm just evaluating advisor fees in this environment.
Well, actually, I do have a strong opinion on that. It's not just from the financial industry. I think good financial people can put information together for lay people that explains the basic economic situation. If you look at the profitability of the advisor, which is always kind of a hard calculation to make, there's always discussions about overhead calculations and things like that, you can still come down to what your profit percentage is and how it's a little more difficult to compare it in the industry. But I do think that, and this kind of goes back to my issue of being comfortable here, if the board is not, I don't think you can always, the more complicated the financial analysis is, you may need to go outside for experts or something. But I think staff, the advisor, should have that kind of talent in-house too. And I think you should first go to staff and say, explain this to me. And they should be able to explain the economics of the situation, the fee structures here. And I know that, fees and costs and distribution networks, 12B1 versus, services, and, the definition of services that benefit the shareholders, that's sort of an interesting fuzzy area in the distribution network. With payments made by the advisor to pay for play, 12B1 fees, and then the transfer agent fees. This is actually an area where our board wants to understand more how all these things go. Now, as I said, I think you can put information together that answers the question, but you don't stop asking until you get the answer. Now, I know I haven't answered your question at all, but I don't think it's beyond. I don't think it's beyond the understanding and knowledge of directors.
Well, is it arguably putting too much burden on directors? Do people still want to serve as directors? Is that?
Well, somebody asked this question before the meeting started, is why would anybody want to be a director? And there's lots of different people in the business, and there's lots of different reasons people would want to be directors, if you will. But being a director in an independent director or an affiliated director, I would say, in a mutual fund, is a big responsibility. And so if they're not up to the task, step aside and let somebody else do it. But there's lots of smart people in the industry, so when you're recruiting people, make sure they're smart, make sure they're patient, make sure that they can go through a process of understanding complex information, because mutual funds are complex. So I think directors should be able to understand the business that they're being paid to oversee. I mean, certainly the SEC and other people say we're responsible.
I mean, you can, just for 1 minute, you can show directors to help them with this, trends in fees. Because after 20 years of the 15C review, they know why the management fee on X fund is 50 or 60. They understand the cost structure of the advisor. They understand how it's built. But what they might want to know is, why did a fund that was running at 110 basis points all of a sudden come in at 127 this year? And maybe if it's a bond fund, that caused it to drop a quartile. And is it just because of it shrunk, and so the TA fees went up, or whatever? But the advisor can provide that due diligence answer. So trends in profitability. It's hard to look at an advisor's profitability just in 1 year without a trend. We don't have a magic number, but we kind of have a magic number from the case law. But the real question is the trend. Why would it go from 22% to 48% in a year? Was it because the fund doubled in size, or did you mess with your methodology or something? So there are ways. I agree the advisor can provide the information. That's what I'm really saying, and I think it's important to give directors trends, and that makes it easier for them to, at least I think it makes it easier for them to trigger a question. and say, okay, because if you don't give them the trend, then they don't know 127 is too high, let's say, I mean, we had a situation many years ago when a fund grew, doubled in size, and yet its expenses went up from 96 to 112, and nobody understood that. That never happens. It's not supposed to happen. The answer was the fund went crazy in the 401k market, and so you had all sorts of sub-accounting fees that got layered in. So you can explain this, but that helps with showing a trend.
Alex, I think Marco had some interesting comments earlier today, and he's observed a lot of boards. I mean, do you sense that boards
Sure,
are struggling with
maybe
this?
maybe I'll jump in here in part.
Yes, and actually, I mean, this does take us to the question of what is the relationship? I mean, what, and if Marco, you could also give us some background on the Janus case, because that really did shed light on the separation and distinction between.
Sure, and I'm going to disagree with both of you on your characterization, only a bit though, and just briefly my background. I am not a litigator. I practice litigation avoidance for the most part across our fund group, and I would add to that division of enforcement and avoidance. We represent independent directors, we represent fund companies, we represent advisors, so really run the gamut. I do have the benefit of having access to some very capable colleagues who are litigators within our firm, and I would I guess echo what you and also Bruce said, that my comments don't necessarily represent their perspectives, but I do think that litigation has been instructive, and there are a couple of themes here that suggest that perhaps in recent years litigation has become a more significant guideline in terms of some of the lessons that can be learned from it. And I'll start with the Janus case. It's been mentioned quite a bit. Many of you have undoubtedly read it. It goes back to June of this year, so it's been out there for a little while. It did not address specifically the director's liability as signers. That was not an issue in the case. What was an issue, the case was brought by investors in the holding company of the advisor. It was not brought by fund shareholders. And the key issue was whether there were multiple makers of the comments in the prospectus about the fund prospectus about the fund not being designed for market timers, even as Janus was allegedly permitting some market timing activity. So I think the case stands, in my view at least, for the proposition that the holding company of the advisor is not a maker of the statements, but left alone what liability the directors have as signers and the fund company has for its own document, which it does own. And so I will agree with you to that extent, but that doesn't necessarily mean that there can't be multiple owners. And in fact, that was part of the dissent in the 5-4 dissent, was that some of the statements in the prospectus that were allegedly contributing to ultimately the holding company, the manager's holding company shareholders' losses were made as well by the management company. Leaving that aside, though, there have been, I think, a number of subsequent cases and developments that I'll just touch on briefly. One is in the context of the SEC's administrative proceeding against one of the portfolio managers of the Schwab High Yield Fund, where there was an opinion that came out of the Northern District of California about 2 months after Janus. This was an August opinion where the court narrowly construed Janus and specifically found that Janus does not apply to the 40 Act standard of 34B liability. They did in that case. The judge did find that the manager's discussion of fund performance, which is an element of the shareholder report, was made by the manager, that there was sufficient allegations that it was made by the manager that it survived the motion to dismiss. One of the portfolio managers has settled that matter, but the other portfolio manager is continuing in his interaction, let's say, with the SEC and the Division of Enforcement. A couple of other cases, just to mention briefly, the Oppenheimer Funds case, there was a ruling out of the district court in Colorado in late October. Again, a denial of a motion to dismiss. This was a class action that named a number of defendants. In this case, it was fund shareholders who were alleging material misstatements and omissions in the prospectus of the fund, and this related to a fund that invested in inverse floaters, and the allegations were that there was inadequate disclosure about the leverage aspects of them, and the fact that third parties had the ability to terminate the trusts, et cetera. That case has extended beyond the motion to dismiss, and the directors are defendants in that case. It's not uncommon for directors to be named as defendants in that kind of a suit based on liability of signers. What is a little bit unusual is that there's also allegations which survive the motion to dismiss that the directors also have an ability to exercise control over the advisor in the disclosure aspects of the fund operations. The other cases that I'll just mention briefly, the U case, which is in the materials that I think, Alex, are in the back of the room. There's a copy of the U case, U versus State Street Bank. The determination in that case was that the plaintiffs had failed to prove loss causation, or to adequately allege loss causation, that the disclosures in the prospectus at issue about mortgage-backed securities perhaps had an impact on their decision to invest in the fund, and therefore it satisfied the what they call the transaction causation aspect of the pleading, but not the loss causation, because the material misstatement, or the alleged material misstatement in the prospectus document, did not lead to the loss. That was not the cause of the loss. That case has been commented on in the industry, and I think a number of observers have looked at that and said, well, if that's the case, if that is the law, then how is it possible that there could ever be liability on a prospectus? How could there ever be a loss attributable to a misstatement where outside of a valuation issue, where the fund is issuing and redeeming shares at net asset value? If it's not a material misstatement or omission that relates to valuation, then the holding in the U case basically stands for the proposition that the loss was not caused by the material misstatement. That case was essentially, or that viewpoint was essentially echoed in one of the Solomon Smith Barney rulings that Bruce mentioned earlier, the transfer agency case, which has been pending for quite a number of years. And there was a ruling in June of this year. It's actually an unpublished summary opinion out of the Second Circuit, affirming a lower court's dismissal of a cause of action based on the same standard, or the same conclusion that the U case reached, that the allegedly excessive fees did not contribute to the loss, or I guess stated more precisely, the disclosures about the allegedly excessive fees did not contribute to the loss incurred by the shareholders. Now, that case is proceeding on 36B allegations that the fees, or the spread between the transfer agency fee that was charged to the fund and the fees that were paid out to the sub-transfer agent that was actually doing all of the work were excessive. So that's continuing these many years later. I think you Dick, touched on some of the implications of some of this litigation, and obviously it's going in different directions, but it's trending towards survival of motions to dismiss. I think one of the things that we're certainly seeing across multiple clients has been a desire to drill down and really make sure that the trustees understand the process. The trustees, it's really impractical, and I don't think is something that the plaintiff's bar would succeed in terms of saying that every director has a responsibility to review every prospectus. But there is, in the Section 11 liability context, there is a defense that would be based on a due diligence defense, where the directors, as signers, would be well served by establishing and developing a due diligence defense to seek dismissal of that kind of an action, like a la Oppenheimer funds. From a practical standpoint, what does that mean? I think different people are taking different perspectives on this. I think at a minimum, at a bare minimum, a desire by boards to fully understand the process, who has input into the preparation of the registration statements. Is it just from a portfolio manager risk disclosure perspective? Is it just the particular portfolio manager? Are there other investment officers that should be or are involved in signing off on risk disclosures? Independent counsel or fund counsel, some outside review of risk disclosures. The Oppenheimer case went on for a dozen or more pages describing the specific aspects and features of inverse floaters that were allegedly inadequately disclosed, and that's issues like the overall structure and how the inverse floaters could operate under extreme market conditions, those sorts of things. Again, the directors are signers to that registration statement, and the case is continuing. I think the process, as a board member, Dick, you're certainly familiar with process types of issues and the importance of developing that kind of process. And one of the, I think, key issues that comes out of the Janus learning and some of the precedent that's out there on director liability. There's a case that dates back to the 1960s, independent directors of a company that had not exercised diligence over a matter. It's the Barcris case. Were held accountable for it. What kind of internal accountability is there? What kind of sign-off process? And how do we as a board, when we're signing the registration statement, which you do, get comfortable that the diligence has been performed to satisfy the disclosure requirements?
Well, thank you.
Sure.
I want to come back to this. Let me ask it this way: has this Janus case set up a more adversarial, more contentious relationship between the trustees and managers? And this is really for anyone to answer, because is it sort of, wasn't it, we're all in this together, and suddenly we're not in this together because we're not liable because there was this 5-4 decision?
Yeah. Well, again, it related to Janus's liability to its shareholders. There are contractual provisions and certainly reviewing or re-reviewing contractual provisions about the responsibility of the advisor and the distributor vis-a-vis the fund company. That's one additional step that many are taking. So I guess I've not seen it in terms of a more confrontational type of issue, but I have seen it as something that has caused boards to go back and review where they stand and what the process is, and look to enhance the process if that's appropriate, if it's necessary.
I would echo that. I don't think the Janus case has had any direct or explicit changes in the way our board operates. I mean, I know I've asked our counsel some different questions about legal representation But they've been mostly clarifying questions, and all the answers I've got have been very satisfactory, if you will. But and to the frankly, we didn't discuss it a whole lot, but to the extent it was discussed, the advisor still assures us that they don't feel like they've got any less responsibility for providing accurate information in a prospectus now. So they're not going to say, it's really up to you guys. We don't, we've done the best we can. Now it's on your shoulders. There, we haven't heard anything like that.
I agree with all that. I suppose I would just go back to my earlier comment where that if the relationship with the board would become more adversarial if you make a statement in the prospectus and then the advisor did something on the side that was contrary to that. That you weren't implementing your directive in the prospectus. And that's what boards oversee all day long. The fund calculates its dividend daily, monthly. You get dividend reports. You find out. What you don't want to find out is the fund didn't pay dividends for 2 years. That's because all of a sudden, the advisor didn't do what it was supposed to be doing. Or if it's a money fund, you don't want to find out that we've been violating Rule 2A7 and we really were running at 110-day maturity for 9 months and nobody was watching. So that's why I think that's where it becomes adversarial. The prospectus is it's standard. It's not going to change. And your quarterly board reporting, and that is really fulfilling all of these obligations and reporting on what you're disclosing. I mean, boards may be a little more careful too with making sure that things are disclosed that you're doing. I mean, we've talked to boards and they will ask, is that disclosed in the prospectus? Is that in the SAI? To be sure, because maybe that has sensitized them to that a little bit. But I generally agree with everything they said.
So this brings me to a question, perhaps mostly for you, Marco, in terms of the role of counsel. Who do you represent? Are there occasions when you represent both management and counsel? And when we talk about we, when the board asks us, is that in the prospectus? Who's the board asking that question of? Are they asking?
Well, probably a room full of lawyers.
So who are those lawyers and what do they do? Tell us.
Yeah, well, the typical structure involves a chief legal officer of a fund that is let's say a borrowed officer from the management company. That's not an uncommon structure at all, and I guess I would say there are probably two models for the rest of the council. I mean, I think there are really three sort of key parties: the advisor, the fund, and the independent directors. I think it is uncommon to have three separate sets of counsel for the advisor, the outside counsel. Now I'm talking about for the advisor, the fund, and the independent directors. It is not at all uncommon to have a single firm that is representing the fund that also that does not meet the independence criteria of the rules that apply to independent legal counsel for the trustees, but does do some work for the advisor, and as part of that work, to the extent and where interests are aligned, where the advisor is interested in looking out for the best interests of the shareholders, does not want the litigation, despite Janus, would continue to feel that it has responsibility for those disclosure documents, desires to build out as strong and robust a 15C presentation as possible, where fund counsel is involved in discussing that process and providing guidance and input to that process, with the independent trustee council representing only the independent directors and standing as a separate, completely independent check on that, and the dialogue and communication flows, or should flow, ideally flows quite regularly and openly with that kind of a relationship. It's not to say that there aren't circumstances and situations where In this, I think, would typically be the more extreme circumstance where a conflict becomes disabling, and it gets to the point where the fund and the advisor and the independent trustees, or perhaps individual independent trustees or committees, should have their own separate counsel. But I think those are the exceptions, not the rule, I guess I would say. And a lot of it depends on the sort of board oversight and understanding of the different roles. The chief legal officer and the executive officers of the fund, they tend to be officers that are borrowed from the advisor. They have responsibilities to both constituencies. They recognize it, they address it, they deal with it. They I think, are open about it and sensitive and aware of situations where perhaps it's the council, the conflicts potentially become debilitating.
I understand there are different models in the industry, and the model that I've come to be most comfortable with is the model that we have in our shop, if you will, where the legal counsel is legal counsel to the funds, and the directors are the director of that fund. So the board of directors and the fund are, if you will, one body, if you will. And I understand you can get separate legal counsel for the directors aside from the fund. That seems redundant to me. I don't understand how that's really useful. But I do see a value in separate legal counsel from the advisor. If for no, I think it's maybe a pure model, but the one thing from a practical standpoint that I like about that model is that if our legal counsel also represented the advisor, then we would have a different feeling about involving our legal counsel in all of our executive sessions, in our 15C deliberations without the affiliated directors and staff in the room. That's such a significant part of our business. And our legal counsel provides so much technical industry, not just legal expertise, but understandings of the business, that not to have that resource to us in our deliberations would be a problem, I think. But I don't think we could do that with as clear conscience if they were trying to serve both masters. And it's not normal operations that cause the problems. When everything's running fine, conflicts of interest aren't problems. They're problems when actually, something bad happens, and then you do need legal counsel with you. Then, that's the wrong time to find out, well, I actually represent somebody else. I mean, to take it too far. I mean, you wouldn't want your legal counsel to represent all your outside service providers. Your trustee, your transfer agents, your advisor, your sub-advisors. I mean, there would clearly be, and I guess the other point, just being a financial person, who pays the lawyer? My sense is that whoever pays that lawyer has some influence over their activities, what they spend their time on, if not what their focus is.
Yeah, and that's not to say, whichever model is used, that's not to say that the independent legal counsel, whether it's independent legal counsel that also serves as fund counsel or strictly the board counsel, is part of executive sessions, and any counsel that also has any sort of duties as a counsel to the advisor would be, at least in my experience, more commonly excluded from those executive sessions.
If you see a man choking in the back of the room, I've said something I probably shouldn't have said.
Now, I'm conscious of time. We have some materials on actually all of these issues, including the issue of the role of counsel, so you can do some further reading. But I do want to see if there are any questions, because we are almost at the end of our session.
And we haven't even mentioned 36B.
No questions. Okay, well, just you did mention something, Marco, that I did want to bring up, just to get some clarity on, which is the topic of loss causation, which sort of you talked about in the sort of midst of the other cases that you were mentioning. Is that something that we're going to be seeing a lot of? Do you think is that UK's an aberration, or is that something that you predict, because it's really does cut things off, and it really is a sea change, I think.
Yeah, I think it is something that the final chapter has not been written on it yet. I don't think you is the final statement on it, even though the court in the Solomon Brothers case, the appellate court, basically took a very similar position. In the Oppenheimer Funds case, as I mentioned, it's too early in that case for the judge to really engage on it, but the judge was quite critical of the approach, and basically said that it would preclude any sort of litigation, and he was unconvinced. And so that is at least one case where it will play itself out. But I think it's fair to describe it as a split at this point.
There's a split. There's a split in the circuits now, right?
Essentially,
so this could see the Supreme Court someday if it keeps getting appealed, which is why Jones versus Harris actually made the Supreme Court, because the Seventh Circuit, Easterbrook's the Seventh Circuit, is that right?
Yeah.
It came out in the case and said, no, Gartenberg doesn't apply, it's trust law. And all of a sudden you had a split on 36B cases in the circuits, and so the Supreme Court took it. So I don't know if any of these cases would elevate, but when you have a circuit split, even this U case the judge made a very strong statement about the fact that you could argue that, if I remember this correctly, that once the misstatement becomes public, if you will, and the fund experiences a run, and then there's a huge loss incurred by the fund due to the run, that you could argue that now the statement caused the loss. Yet we're not adopting that. So this could vary. Their argument is that an NAV is calculated by formula and not like a market price that is set by public information. And that's how they. Am I describing that sort of correctly? So this could get elevated, but.
Okay, thank you very much. That concludes our panel.